paketi hapo. Hiyo moto wako ya
Wszystko wciekli.
Come on, 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 come on,
Come on,
这只。 agak brown ya.
deliver the judgment.
Kamera mrefu sana kuyafoka, sio mbali kidogo itakata. Ameketi hapo.
That's people are waiting for the result. When does everything get those points? It's coming this year.
Honorable Justice Eric Ogola, Honorable Justice versus State Law and others.
For the first petitioner, Ogeto, who is a Jesuit council appearing for the
And I'm for the second petitioner.
Alongside my brother, Mr. Sakimba, we are here, which is represented by the following.
My Lord, the presiding judge, my Lord and my lady, if it pleases you, my name is Wamboi, Mr. Samson Nyaberi. Miss Wanjiko Waithera, and your Lordship, together with and Mr. Peter Koira. If it may please you, my
Nyamu, we appear for the
Goi, appearing for the 43rd fellow councils, Omoke Murara and Sasha Wamai.
My name is Mosongo. I appear for the 7th
council. I do appear for 3rd interested party.
Interested party, and I appear together with Mr. Steve Ogola.
May it please the court, instructed by Christopher Marwa, represent Paul Nyamodi and Elias Oum, 3rd and 4th respondents, my learned friend, Professor Dr. Thionkolu, Mr. And Ms. Gafira is holding for the 10th respondents. Are instructed by the 16th responses. Amend the representation of the Speaker S-O-R-E-H. Sorry.
E586. And my Lord, my Lady, the 4th of June, the same petition was not heard. 7th of May, you had ordered directed be heard in the 4th. It was listed for hearing. Because you're together with that, would now court, because the Honorable Chief Justice had appointed your lordships and hearing aborted. We filed an urgent 91 of 2026. I also wrote attention the precipitate injury. Accordingly, the Court of Appeals this morning, I served on the authority of the Court of Appeal, the matter being sub judice in the Court of Appeal, to arrest Section 20, subsection 1H of the High Court Administration alerted me, asked me if, or in deference to the Court of Appeal, that this honorable, the right to be heard, being enshrined in Article 25, you find, as indeed you would find, that in the impeachment, you render the decision according to the list. In deference to that constitutional, the rendering of this judgment, we can be heard tomorrow because we filed. Thank you.
Do you have an order from the Court of Appeal?
My learned friends will be aware. Has the
judgment?
As we speak right now, no, because the
some of the parties here to respond to that.
May I finish before they respond? At least want to bring any theatrics or sabotage to the Court of Appeal is the aborting of the hearing. My Lord friends can respond. On the 7th of May, the podium, so that then you could address everybody in E586, 4th of June as a hearing date. On ground that that petition was to be heard before judgment was given. Thank you.
We have not taken in record who are expecting a judgment.
My lords, my ladies, the judgment in the petition before you, as a matter of fact, not participating. And therefore it will be very curious for us to get a judgment today, interfered with the matter in which we are not participating. Leave our judgment as scheduled today. That's all.
Of the 44th petitioners, my lord. The fact that that file is not before you, my lord, cannot form the my lord, or arresting the judgment, my 9th petitioners, my lord, is that to render you this afternoon, my lord. We are opposed to that application.
Speak for all my colleagues, for the respondents.
Thank you.
My lord, on behalf of the third interested party, we associate ourselves with the before. I thank you, my lord.
Thank you.
We associate ourselves with submissions of see no need of stopping judgment. That's all.
And my ladyship, appearing for petitioner, we also associate ourselves with the submissions of stations to deliver the judgment. We then oppose the application.
Consolidation. We were together with Mr. Masini. He has his day in court. The court can give directions in his petition that have been given by Mr. Ongoya that we proceed.
Thank you.
I will wish to fully associate myself with the submissions made by him. Over and above that, perhaps it will benefit the court to notice, even if we are to agree, we have not been given enough or sufficient time to proceed with the business of the day, to can pursue his claim at the Court of Appeal. Thank you.
Point is made, my lord. I will add the following. One, that the Court of Appeal will ultimately grant his request he makes as we speak. Number two, held in abeyance pending the delivery. Number two, or rather number three, my lord, the record will show to scuttle the process. This is just one.
Thank you very much. There is no need. Secondly, a voice has been raised there on the 29th of May last year, impromptu and afterthought, 2025, deconsolidated this E586 of decision. Yes, he did, and yes, he has. The 7th of May on a constitutional duty. My lord, I served that application from the Court of Appeal in deference and pretend as legal practitioners. We do not know the practice of the Court of Appeal. The Court of Appeal is seized of those proceedings, which everybody here reference to that constitutional issue. The other issue raised is that from these consolidated petitions, Lieutenant Counsel, really, having looked at my petition, 10th respondent, your lordship, he cannot be heard to say that he has the peculiarity of that petition. You so 5C says he should be heard and given that right to a petition comes up for hearing, should they ever remove from my lord? I say so because threshold was never met, and I'm not delving into that. So please don't point a finger at me. None of them should be heard to say that my...
Mr. Kinanjay,
yes,
we have given you enough time.
Yes, this is my last. Since the Honorable the DR received these formal comments referred to the Court of Appeal, and I say adjourning indefinitely. It's not open-ended. Even give me this afternoon.
Mr. Kenya, the matter you are referring to is not before this court, either by way of a mention or a hearing or a judgment. Indeed, it is not before us, and we are not able to take notes on that matter. Many people here may not know where you are coming from. I gave you the orders. The way you took yourself away to represent facts. The Court of Appeal matter. If they wanted to stop us from the Court of Appeal, then we'll drop our pen. We don't have that. Lastly, we gave directions to the left matter will be mentioned after today. This is the last comment we are making on this issue. Your matter is coming 2026. Parties before the court.
Thank you very much.
What time is it? In 2024, consolidated with Nairobi Petition 572 of 2024, Petition number E014 of 2024, for Nairobi Petition E509 of 528 of 2024, Nairobi Petition number E537 for E586 of 2024, and His Excellency Gachagua'S Munyi Madenge, Peter Gichobi Kamuhi, Father Eddie Waikami Njuguna, Peter Kimani Kioira, Muchiri Ngatia, Maria Njeri, Eric Margaret Wanjira, Samuel Njenga, Hebron Gakuru, Honorable Attorney General, and several others.
Clarity. The lead file in terms of the directions that this honorable court, quite what I heard.
Yeah, that is the lead file. We have a 350 page judgment. Introduction and background. Herein, after referred to as His was elected as the Deputy President of the Republic of Kenya, along we refer to as President. Their election was upheld by the Supreme Court constitutional term under Article 145, sub-Article 1. That expectation, however, was cut short against His Excellency Gachagua. commenced on 1st of October 2024, when Honorable Mwengi Mutuse, the 9th respondent and member of impeachment motion, pursuant to Article 140 and Article 150 of the Constitution. The motion hereafter refers grounds, including allegations of gross violation of the Constitution, incitement and undermining government policy. 10, sub-article 2A, B, and C, Article 27, sub-B, Article 75, sub-article 1C, and Article 120 of the Constitution, grant 152, sub-article 1 of the Constitution, undermining the President and the Cabinet and effective discharge of the national government through A, Article 174, Article 180, the fourth schedule to the Constitution by resolution 4, Constitution on the institutional and decisional independence of judges, Article 5, Ground 5, of the Constitution, and fidelity to the oath of office. Serious reasons to believe that Rigathi Gachagua are of the national cohesion and integration. Ground 7, serious reasons to believe that Rigathi Gachagua committed crimes under Section 45, 46, 47 Economic Crimes Act and Section 2, 7 of the proceeds of crime and money and Ground 8, serious reasons to believe that Rigathi Gachagua has committed crimes by continuously public through false, malicious, divisive, and insightful remarks contrary to the provisions of Section 132, 29 of the Leadership and Integrity Act. Ground 9, gross misconduct and undermining the work of the national security and its officers. Ground 10, or insubordination by openly or publicly insubordinating the President, ruling state and of public officers. The impeachment motion National Assembly. In response, several constitutional petitions were filed of the National Assembly's proceedings. These petitions, consolidated with Nairobi designated as the lead file. 5-6, that was cohort 1 petitions. Cohort 2 petition, the National Assembly passed the impeachment. As the impeachment process unfolded, seeking conservatory release were filed in the High Court to restrain the Senate from proceeding with impeachment hearings. The Senate thereafter conducted its hearings, held office as Deputy President of the Republic of Kenya. The Senate's decision, His Excellency President Ruto nominated Professor Kithure Kindiki President. The National Assembly voted sworn into the office on 1st of November 2021 were underway, and while the National Assembly created in the office of the Deputy President, further petitions were filed in the High Court at 5 of 2024, being designated as the lead file. 1st of October 2024, paving way for the swearing in, summary of pleadings and submissions, 13th of August 2025, October 2024, and 27th of October 2024. Agencies in the process before the National Assembly, His Excellency Gachagua deposed that the impeachment motion, he took issue with the lack of credibility in respect of the participation. His Excellency contended that the National Assembly's process was deficient in that the venues. It was his case that the exercise was biased with verified feedback forms that is fictitious data. In alleging bias, Excellency deposed that they made partisan despite having conflict of interest as they were signatories to the coalition agreement by denying him a crucial layer of fair hearing, that the Senate violated his right to a fair hearing when he was denied an adjournment. In further confirm the medical status of His Excellency Gachagua on the day he was at 3 p.m., His Excellency Gachagua arrived at Karen Hospital, including hypertension, history of diabetes, stress, 8 to 72-hour admission to enable close monitoring further until discharge on 20th of October and approval of His Excellency Kindiki. He asserted that 18 of the Constitution. It was his case. Independence Electoral Boundaries Commission, or IEBC, was null and void since the commission lacked commission. It was His Excellency Gachagua's position that due to gross human rights violation, including abductions. Finally, His Excellency Gachagua averred that the Assembly unconstitutionally metamorphosed. For these reasons, His Excellency Gachagua sought the full Article 118, Sub-Article 1 of the Constitution, adequate legislative and procedural measures for effective public participation, lacks the particularization and specificity required of both the National Assembly and the Senate under Articles 145 and 150, and the communication of the National Assembly on a special motion on the removal from office by impeachment in violation of the Constitution of Kenya, and are thus both void. And 290 electoral constituencies in Kenya, 450 electoral wards where the presidential election takes place. Understanding orders number 64, sub order 2 and 6 of the National Assembly is grossly insufficient time for the National Assembly during the process of impeachment of the President or Deputy President. It has the effect of abridging for public participation. 6 is whole house stock plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited or time-bound. He also sought legislative action under Article 50, Sub-Article 1 of the Constitution, denied an adjournment occasioned by illness and present his case. He also sought proceedings before them, failed to properly assess each of the voting to uphold the impeachment charges against the petitioner. Hence, the resolution of impeachment charges, that of the Senate, passed on 17th of Sashorarai to remove into this honorable court and calling to remove from office by impeachment His Excellency Rigathi Gachagua, EGH. The resolution of the Senate of Kenya made on 17th of October 2020, Republic of Kenya, on the ground notice number 13-400. 11, a declaration does issue that the IEBC Article 88 and Article 250 sub of the Constitution as read with Section 4 and Section 11A of the clearance as therefore further overnight clearance violated Article 10 of the Constitution on open at prayer number 12. His Excellency sought a declaration that a gross violation of human rights. He also sought a declaration that Articles 124 sub-article 4 and Article 149 sub-article 1, Section 6 of the public adopted to approve Kithure Kindiki as Deputy President. He also sought a declaration that Kithure Kindiki was illegally appointed and unlawfully approved as nominee for Deputy President in violation of Article 137, Article 148, Article 149. Appointment, clearance, and approval for that position is null and void. That the petitioner suffered harm and is therefore entitled to constitutional damages, punitive and aggravated damages, security to be specified at the hearing, special damages under Gazette Notice Number Transport and other prevailing transport policy for 35 months, to be supplied airtime, gratuity, he calculated those sums and sought pension and other benefits under the Retired Benefits Deputy President and Designated State Officers Act. First petitioner's last monthly salary while in office as a sum equal to 1 year. 3, 2 saloon vehicles of an engine capacity not be replaceable once every 4 years. 4, of the current monthly salary of the office. 6, full medical and hostel cover, providing for local national's child who is below 18 years or is under 25, female child is not married or is not cohabiting with any person. 7, 2 drivers. 10, 1 secretary. 11, 2 housekeepers. 13, 2 cooks. 14, 2 gardeners. 15, armed security guards who shall be provided on the spouse. And 18, office equipment. 19, maintenance expenses provided. 20, access to the VIP lounge. Course of this petition and such other reliefs as this court may. In support of his claim, Gachagua'S submitted, or rather in his submissions, he advanced his case further through written submissions dated 7th of October 2025. Counsel, Elisha Ongoya Senior Counsel. The unifying premise submissions was that the impeachment proceedings were regulated proceedings subject to the supremacy of the Constitution. The jurisdiction of this court under Articles 23, 47, 50 met the constitutional threshold under Article. Whether the Senate violated Articles 145 sub-article 3 to 6, misled by its of Article 145, rushed the process and denied the petitioner a fair hearing. Assembly and Senate were biased in perception. F, whether the overnight clearance and process. G, whether standing order number 6. And then, lastly, what are their for His Excellency, the petitioner, Rigathi Gachagua. Parliament undeniably possesses the authority to undertake impeachment. Such authority or procedural impropriety arise. The engineered process disguised as constitutional compliance, submitting that Parliament specifically observed procedural forms while the constitutional standards of the process. Learned Senior Counsel Elisha Ongoya in Kenya's presidential order, he submitted that the Constitution transformed governance and accountability, which rendered all exercise of public power, including parliamentary impeachment, submits as an exercise in malicious, drew parallels to the historical Sir Thomas More and Jesus Christ to demonstrate how processes can appear outwardly lawful, just and predetermined. He maintained that constitutional democracy to fairness and constitutional morality, not merely technical. The text of Article 145 and Article 150 noted that the threshold language, gross violation, gross misconduct, and serious reasons is a mechanism reserved strictly for the gravest constitutional transgressions. From the cases of Mike Sonko, which we have Muya and versus Tribunal to investigate the conduct of Justice Martin Muya, we have given citation that grounds must be substantiated by cogent evidence higher than a balance of probabilities. Senior Counsel Ngoya further submitted that through universal suffrage, courts could not abdicate political immune process. It was his case that the grave consequences of removal brought the matter squarely interrogate whether Parliament met the heightened constitutional standards. Senior Counsel Paul Mute submitted doctrine. He was emphatic that impeachment in Kenya's ordinary constitutional remedy of last resort. He where executive tenure relies on confidence. It was his case that the deputy president derives direct democratic legitimacy from the electorate moved due to transient political dissatisfaction or convenience. In view of the fact that impeachment effectively overturns the deliberately imposed strict procedures and substantive that courts are duty-bound to enforce. From the decision in Mike Sonko Mbuvi, which we have stated, expediency, he further called to his aid the Court of Appeal decision in Martin Nyaga Wambora. We have given citation. Supremacy rather than offend the concept of respondents' invocation of the political question doctrine, autonomous islands immune from accountability, and personal power remains subordinate to the judiciary's review. Limited on jurisdiction and the mandatory duty out an alleged internal contradiction case, simultaneously conceding the constitution while urging it to abstain from exercising it. His adjudication could not be avoided simply because a dispute implicated that once allegations of procedural impropriety or rights infringements arose, the process ceased to be on the United States Supreme Court decision in Cohens versus Virginia that a court acts just as improperly when it declines as when it arrogates jurisdiction it does not possess. Imposes a mandatory obligation to determine disputes whose are alleged as such the judiciary politically sensitive questions. separation of powers does not establish institutional and that judicial review ensures Parliament acts within its boundaries. That constitutional interpretation in such disputes than mechanical. In the written submissions, His Excellency Gachagua'S Judgment already declared unconstitutional Robert Alai versus the Attorney General matter on the right to a fair his inalienable right by proceeding in his absence due to he drew support from Karaoke versus circumspection. He further submitted that the rushed manner in Olo versus Kisumu County Assembly Service Board and another. Public participation and institutional incapacity, it was His Excellency Gachagua'S of Wajir, and it must be substantive, one that reasonable time and utilizes satisfactory mechanisms. From the decision Independent Electoral and Boundaries Commission vs. Attorney General 2025 not be lawfully discharged by the Secretariat of a properly constituted commission. In their rejoinder submissions, the legal team also that the Senate lacked a lawful resolution that the word may in Article 145 sub-Article 3b regarding things of trademarks and another. They submitted that courts rotated to effectuate legislative intent. It was their case that it proved the firm to any plenary vote. In conclusion, His Excellency Gachagua'S drew inspiration from the citation to reiterate that impeachment processes remain strictly subject to the Bill of Rights to check grave abuses of discretion as established in Imanyara and two others versus Attorney General was right and deter future legislative infringements.
I will proceed from the second petitioner, Maingi. The second petitioner in the consolidated petitions filed a petition 2024 before the High Court at Kerugoya. The petitioner described himself as a former member of the National Intelligence Service, NIS, and contended Excellency Gachagua on 26th of June 2024 concerning the conduct of NIS during the finance. Served in the NIS for over 20 years before retiring in May 2022. He was publicly associated with the intelligence service and unrest and loss of business during the protest. He has the remarks exposed him to ridicule, hostility, threats, and psychological distress, forcing him to temporarily leave his home in Kirinyaga. Safety. Mr. Maingi further contended that the duty as the principal legal advisor to governments 24, 25, and 26 of the National Security Intelligence Service Act relating to the petitioner 8, 29, and 47 of the Constitution to discrimination, infringement of human dignity, torture, and unfair administrative conduct. Consequently, that there be a declaration that the constitutional rights of the Articles 10, 27, 28, 29, and 47 of the Constitution have been violated. In order to issue an apology to the and staff for the utterances and or speech made on the 26th of June 2024. relief the court may deem. The second petitioner's case. Honorable filed the petition dated 2nd of October 2024. That was later amended on the 9th of October 2024 before the High Court at is the current woman representative in the National Assembly for Kirinyaga County. Of Kirinyaga County and in public discretion and in public interest, also principally challenged the constitutionality, legality, His Excellency Gachagua. She contended taken by the National Assembly in relation to the impeachment motion was ineffective. She took issue with the insufficient dissemination of information, comply with court orders directing constituency level public 47, 48, 145 and 150 of the Constitution and challenged the constitutional proceedings, thereby undermining meaningful public impeachment proceedings in plenary instead of through a special committee. Impeachment charges could only lawfully be undertaken. In addition, she challenged the legality of the principle under Articles 27, 81B, 102. Honorable Maina sought for the following: that the modalities put in place by the first respondent in respect regarding the special motion fell below the threshold of proper effective in respect of the public participation on 4th and 5th motion were in disregard of the court's orders and fell below the threshold of interested party undertaken of modalities of public participation forums held on the 4th and 5th October 2024, constitutional and therefore void. A select committee by the Senate under Article 145 in the impeachment of a president or deputy president in light of Article 259, interested party taken by the second and fourth petition, Article 145, Sub-Article 3B of the Constitution are unconstitutional. Mandatory provisions of Article 27, 81B, 102, 68 as currently constituted cannot entertain and of the first stated party by respondents. H or orders that this court may deem. The third petitioner's submissions. Honorable Maina 6, and we further orally highlighted in court. She identified the following issues: 4, met the constitutional threshold under Article 1. The National Assembly violated constitutional requirements for meaningful public participation at the Senate stage. 4, whether the Senate of 11 members. 5, whether Standing Order 64-2 12-day impeachment timeline is constitutional. And 7, whether the impeachment as required by Article 50, Sub-Article 1 of the Constitution. Submitted that on the 3rd of October 2024. Honorable Justice constituency levels so as to accord the public an opportunity to engage and were never appealed, stayed, varied or varied. And as such, they remain binding on the respondents absolutely. Speaking to the obligations in Law Society of Kenya 24 KEHC, even to cases where the person affected by an order, utensils limited versus bill application number Nairobi 1339 of reasonable notice and not the same day or the next in each of the 290 constituencies, facilitation of engagement, disability access and hearings As the primary Monarch Council further submitted that only 200,000 participants countrywide, 0.4% of the Kenyan population, up for the exercise. Council declared the one-day contents were vague as they referred to constituency offices without addresses and times. She also pointed out that no hearings were ever organized, no facilitation was provided, and that CDF offices were closed and the MPs absent. Honorable Maina, aware of the purported exercise only past midday, and that none of her counterparts within the venues found them locked. Staff were inside. Admitted that the National Assembly faced a binary choice of obeying the Constitution through the court order or preserve Standing Order 64, which provided for 7 days deadline. They chose contempt addressed a legislative outcome obtained in defiance and in a constitutional democracy by the rule of law as discussed by Lord Denning in McFoy versus United Company Limited, reported in 1961, 3 All African, All English. The learned judge held that, I quote, if an act is void, something on it and expected to stay there, it will collapse, end of quote. The yes and no template as constitutional fraud, as the National Assembly deployed as into binary tick box questions that citizens on each ground without being supplied with evidentiary material, explanatory memoranda, and His Excellency Gachagua'S response, relying on for Health 2019, which we'll hereinafter be referring to as attributes of meaningful participation to include clarity for the public to understand structures, processes that are clear and simple, opportunity for balanced influence from public, commitment to the process such that views can influence representation. She also the process and capacity to engage on the part of Honorable Maina admitted that the digital systematically excluded rural residents, the elderly, no physical venues for explaining views that were only in pictures of people attached as evidence of attendance for the 5th October exercise, and that they were contained and that they were conflated responses on 5th October without distinction, obscuring the impact. Identified that the template was not a procedural perfection, but an endorsement mechanism designed to manufacture and is therefore constitutionally void. Her further submission that Article 118 imposes an independent obligation on each House of Parliament to facilitate public participation in its own business. Appendage of the National Assembly, as was held in Speaker of Senate versus Attorney General, reported in 2013, where terminative under Article 145 forms a quasi-judicial function of the highest constitutional order. she held the position that the Senate could not constitutionally rely on the National Assembly's defective process, particularly where that process was conducted in defiance of court orders. That the Senate was aware of these defects as documented, litigated, and judicially submitted further that in Mwangaza versus Speaker of the Senate 2025, reported in 2025, that public participation was adequate and satisfaction. Conducted no public participation whatsoever, as no notices were issued, conducted, and no submissions were received, and that this is not a case of none at all. It was also her submission that Article 145 Sabat provides that the Senate may appoint a special committee to investigate the matter. On that, the word may of power, not a license to bypass the Constitution, and that once the Senate had elected to proceed under Article 145, it must proceed within the architecture prescribed, which includes a further stated that under Article 145, Sub-Article 6, if a special committee reports that allegations absent a committee report, the gateway to plenary determination was not opened. She also stated that the constitutional function of the special committee was structured investigation, not political debate, receiving and insulating investigation from the volatility of plenary. That Article 145, Sub-Article 5 of the Constitution, guaranteed the President the right to appear and be represented before the special committee, and by bypassing the committee to the Deputy President, thus violating the derogable right to a fair hearing. Admitted that standing orders confirmed this. Standing Order 79 on the Deputy President impeachment provided for a special committee, but no alternative. Procedure impeachment expressly provides two alternatives. That is, posited that where the drafters in plenary investigation, they could have said so. The President must be respected. Learned Counsel of the County Government Act, which provides that the Senate may appoint a special committee in governor impeachments, and that the courts, including Wambora, this confers discretion, and the Senate has lawfully that those decisions underscore the opposite point. Expressly provides alternatives. Discretion exists, but where the Constitution provides a negative pathway, the discretion does not extend to inventing another. She submitted that by proceeding to plenary determination without appointing a special committee, the Senate acted without jurisdiction and extinguished a guaranteed hearing rights. She also submitted that Senate had collapsed constitutionally distinct phases into a single political exercise, and the and void ab initio. It was a further submission that Standing Order 64-2 lay at the heart of the constitutional infirmity, as it imposed unreasonable timelines that rendered compliance with the Constitution impossible. Council invoked Article 2.4 is void to the extent she placed reliance on Orange Democratic Movement Party versus Speaker of the National Assembly, reported in 2024, where this court affirmed that standing orders cannot override the Constitution nor substitute the of public participation as expounded by the courts. In that light, Parliament halted, it being argued that Standing Order 64-2 structure compliance. She submitted that where standing order made adherence to constitutional obligations impossible, such a standing order is itself unconstitutional. That Standing Order 64-2 embodied a deliberate parliamentary choice to prioritize political expediency over prescribing rigid timelines. It ensured that once an process would be driven to conclusion before courts could intervene meaningfully or before the affected office holder could mount an effective defense. This was precisely what the Constitution sought to prevent, since impeachment judicial constitutional process carrying grave consequences. On that basis, it was argued that this court should declare Standing Order 64-2 unconstitutional, null and void to the extent that it prescribed timelines incompatible with constitutional requirements, and that any impeachment conducted under its terms is tainted with the inception. On the question of whether his hearing, Honorable Maina submitted that he was hospitalized with chest pains on the eve of the Senate proceedings. Despite incapacity, the Senate proceeded with a hearing and voted thereby of the fair hearing rule, audi alteram paltum, meaning no person shall be condemned unheard. Counsel further argued that the 12 days between service of the motion and the national inadequate, given that Article 50, Subarticle 2B guarantee the right to sufficient time and facilities to prepare defense. His Excellency Gachagua, it was emphasized, faced 11 complex allegations, including gross violation of the Constitution, abuse of office, and corruption, for which 12 days was structurally insufficient. As the Supreme Court affirmed in Sonko case, attract the protections of Article 50, and where a fair hearing is denied, the process collapses. On the issue of bias and premeditation, the Senate Council submitted that both Speakers of Parliament as presiding officers over the impeachment motion were contained impartiality but acted contrary. Assumed the role of initiators and proponents of the impeachment, thereby transforming into advocates for the motion rather than. In particular, Speaker Moses Wetangula of the National participated in public statements endorsing before presiding over the proceedings. That the test for bias is objective, where a reasonable, fair-minded observer would conclude that there exists a real possibility speakers, public statements and advocacy for impeachment of the speakers to rescue themselves. For above reasons, Honorable Maina urged the court to grant the relief sought in her petty cases. Petitioners in the consolidated petitions, that is Honorable Dri Muriuki and Edwin Munene Kariuki, jointly filed a petition dated 18th of October 2024 before the High Court. Presidents and leaders drawn from various constituencies within Kirinyaga of their respective constituencies, legality and procedural propriety of the impeachment proceedings undertaken against His Excellency. The suspension process conducted by to the issuance of a short and ineffective of parliamentary Central CDF whole, and the overall failure by both National Assembly and the Senate to facilitate through a special committee and Article 145. Two of the National Assembly standing orders were unconstitutional as they curtailed Excellence Gachagua'S Judgment and medical emergency, thereby denying him an approval process of His Excellency Kindiki as Deputy President nominee, contending Approval Act, Chapter 7 of the Laws of Kenya, for want of a declaration that the appointment of Professor Keith Republic of Kenya is invalid, null and void. Its own distinct, proper, under Articles 10 and 118 of the Constitution in regard to the impeachment of a president, distinct, proper, effective, and meaningful as envisaged in regard to a resolution from the National Assembly in Articles 10 and 18 of the Constitution. A declaration that of the court orders issued by the High Court sitting at Kerugoya in constitutional participation as envisaged under Article 10 of the Constitution. The first interested party was undertaken by the G, a declaration that the failure by the third and the fourth respondents to renders the whole Senate impeachment process unlawful and to bring up into this honorable and quash the decision and the resolution by the first respondents met on the 8th of October 2024 and 17th of resolving to remove the first interested party as Deputy President. That there exists no vacancy in the office, such nomination is unlawful and void. J, just and expedient in the circumstance. Next is the 4th to 8th petitioners. Evans Ogada, together with Mr. George Sakimpa. The 4th to 8th petitioners identify the following process complied with Articles 10, 118, 145, and 150 of the Constitution. Assembly and the Senate met the constitutional threshold of being meaningful. See whether a standing order of the National Assembly
are a group of Kenyan citizens and one registered association region. They filed the petition dated the 7th and re-amended on the 16th. Validity of the impeachment process and stating that the national comply with Article 152 of the Constitution, which requires them to add that instead they apply the age or legal immunities as the petitioners aver that this failure rendered the entire impeachment process the right to a fair hearing under Articles 25, 27. It was their further position that the impeachment was not a genuine parliamentary process, but was engineered, sponsored, and bulldozed by political and financial. Remove the DP and settle political scores, thereby subverting the 2022 general election. They asserted that the president were elected on a joint ticket and that the impeachment petitioners and other voters from the Central Kenya region also highlighted and incorporated arguments from Nairobi High Court Constitutional Petition 356 of 2024. In that matter, it was alleged that both Truto and H.E. Gachagua had violated their oaths of office and the Constitution through various actions. Specifically, it was claimed that the President accepted foreign gifts valued at approximately 40 million in the form of paid for jet hire and fuel costs for a state United States, thereby exceeding the legal threshold permitted for such gifts. It was further alleged that the President entered into a secretive treaty to designate Kenya as a non-NATO ally without tabling the agreement before the National Assembly oversight. Additionally, included intimidation and threats directed at members of parliament to oversight, as well as inducement of political defections to artificially control the majority. Accused the president of using state violence to criminalize and suppress the Gen Z, otherwise read the Generation X good governance protests, as well as the July 2023 protests against oppressive taxation and the high cost of living, and that he distributed state appointments along acute ethnic lines. Additionally, H.E. faulted for publicly dividing Kenyan citizens into shares. H.E. President Ruto is accused of spending hundreds of agreement binds H.E. President, which is the same region as the impeached deputy president. 99 and 137, state participation across all 90 constituencies. Void. The petitioners thus sought be issued to declare that the first petition procedure that violated Articles 20. 2. A declaration be issued. Respondents have violated the rights of the petitioners and region by failing to govern together in accordance with presidential election held on the 9th of August 2022 by the Parliament under the respective standing order. Article 150 sub-article 2 of the Constitution. Declare that the impeachment of the first petitioner was null and void ab initio on account of the violation of Articles 25, 27, and 50 of the Constitution, read together with Articles 144, 145, and 150 of the Constitution. 5. A declaration be issued to declare that the second and third to 14th respondents have conspired and schemed to remove the second respondent from office through impeachment in violation of Articles 1, 27, and 38 of the Constitution. 6. A declaration be issued to declare that the second respondent violated Articles 110, 118, and 150 of the Constitution in passing a resolution on 8th October 2024 to remove the second respondent from office. 7. An order of certiorari be respondent passed on 8th October 2020 to approve the motion of impeachment of the first petition. Declaration be issued to declare that the sixth respondent's power Article 149 of the Constitution to nominate a person to is subject to certification by the independent under Articles 99 and 137 of the Constitution. Declaration be issued to declare that the 14 days prescribed under Article 149 for the President to is to ensure compliance with Articles 10, 30. Declaration be issued to declare that the 60 days of the Constitution for the fill the vacancy in the office. Your compliance with the requirement of public participation in all the 290 constituencies in 118 and 136 of the Constitution and 38 of the Constitution. The first respondent is bound by the Kenya Kwanza Coalition, Embu and Meru communities to fill the vacancy by the impeachment of the second respondent. 12. That the sixth respondent's nomination and of H.E. Honorable Kithure Kindiki, the second interested party hearing, is to issue an order of certiorari to quash the nomination notice published in a 18th October 2024, and for that by dint of Articles 1, 10, 27, 38, 9, 22, to have one of them to occupy the office. Orders number 64 and 65 of the National Assembly Standing Order, an order of certiorari be issued to quash Standing Order 6 that they apply to the Deputy President. To declare the Standing Orders number 79 of the Senate adopted Article 152 of the Constitution. 18 adopted on 16th June 2024 to the extent that they apply to the second and fourth respondents hearing to promulgate impeachment envisaged by Article 152 of the declare that the first petitioner was impeached through petition and vendetta prescribed by 1, 3, 38 and 50 of the Constitution, sponsored and bulldozed the impeachment in violation of Articles 1, 3, 38. Petition be borne by the first and fifth respondents. The 10th and 41st petitioner's submissions reiterated that the impeachment proceedings did not stem from legitimate constitutional violation, in quotes, between H.E. President Ruto and H.E.MP, Honorable John Waluke, from a high-profile corruption case. Honorable Mutai has listed the following issues for the court's determination. For witch hunt or a genuine procedure. B, whether and 152 of the Constitution. C, whether the standing orders number 64 and 65 of the National Assembly and Article 152 of the Constitution. E, whether the Senate of H.E. Gachagua'S null and void ab initio, whether the first to 11th respondents conspired or schemed to remove H.E. Gachagua from office in violation on the weaponization of that the impeachment was completely manufactured by a police of any lawful grounds under Article 151 given Parliament to use the sacred device of impeachment. Submitted that the impeachment proceedings inside both the National Assembly of substantive and procedural provisions guaranteed under the orders 64 and 65 violate Article 150 sub-Article 2. The petitioners equally submitted that H.E. please subject to certification by IEBC 14-day and 16-day constitutional windows participation across all 290 and approval of H.E. Kindiki. That rushing this violated the political right under Article 38. That this court has an obligation to step in executive scheme to re-establish an that Parliament has become subservient and sycophantic to the of the late 1980s, which presents an existential threat to constitutional democracy. They restated the prayers that sought to declare 750 and 150 of the Constitution, and his 8th October 2024 resolution, motion, and Gazette Notice 13401, which appointed Order 64 and 65 and Senate Standing Order 78, both chambers of Parliament, to promulgate to Article 2. The petition, the Sonko case earlier mentioned, also relied on foreign authorities, including R versus Campbell, R versus Reagan, based on books, articles, speeches, and interview statement by Senator 24 and an interview statement by H.E. Gachagua. Petition be allowed as prayed. Moving on to the petition dated 9th October 2020. Kenya at Eldoret, together with the supporting affidavit, as a Kenyan citizen and patriot acting in defense of the impeachment proceedings commenced against intended that the impeachment process was politically motivated, centered on the alleged violation for 1, 10, 38, 47, 18, 145, and 150 participation, and that the M failed to consult their constituents before impeachment motion was tainted by of signatures belonging to some MPs, metic and incapable of constituting. Because it was hurried, poorly coordinated, inadequately publicized, his responses, thereby fairness and natural justice. He also alleged bias, and he contended that both office holders' constitutional obligation to act and impartial arbiters during the proceedings. He, as parties involved, had failed to exhaust internal party dispute resolution, comprehensive statutory framework governing impeachment process efficient and constitutionally uncertain. That the impeachment motion moved by the respondent does not meet the threshold set out in 150 of the Constitution, be of Geoffrey Rigathi Gachagua was unconstitutional. The Speaker and Deputy Speaker of the National Assembly were biased and ought to have 32, 33, 50, 73, and 75 of the Constitution was tabled in a manner that violates Article 1. Participation was conducted by Honorable Mutu. Their signatures prior to moving the impeachment motion in the National Assembly, a result of a dispute in the United Democratic Alliance, contrary to the exhaustion doctrine. G, a declaration that in the operationalizing the provisions of Article 150, of which the impeachment of the DP was anchored, and H, that namely, whether the impeachment of H.E. Gachagua was unconstitutional, and whether the lack of operationalize Article 150 of the Constitution vitiates. He wholly adopted H.E. Gachagua's submission 25, submitting that the constitutionality evaluated with a view to advancing constitutionalism and the rule of law. He maintained that public participation was inadequate and a sham, as the mover of the motion and the 291 MPs who appended their signatures in support of the in their constituencies before signing contrary 118 of the Constitution, that public afterthought, and when questions arose on 1st October 2024, directed that it be held on 4th October. Advertisement appeared on 2nd October 2024, which Mr. Public participation from the that the public participation form provided by the National Assembly contained only the allegations against H.E. denying the public the ability to effectively weigh the grossness of the alleged violations. For only 9 hours, from 8 a.m. to 5 p.m. on a normal work, which was a Friday, meaning most Kenyans could not attend. That venues were changed on the eve of the exercise. For example, in Embu, it changed from IFA. He submitted that in Kiambu constituency, in a county with over 1 million registered voters, that as utter pandemonium akin to the power tower. There were incidents of forms and a vehicle ferrying pre-filled forms. National Assembly following day on the 5th of October 2024, but he added that in some constituencies like West Mugirang, the one center per county and should have been conducted at least at each polling station or at minimum each one. Gladys Boss Sholei of being biased in that function in Uasin Gishu County, she swore to spearhead the impeachment motion. That she also hinted at some of the grounds of impeachment September 2024 while attending a church using the biblical description in Mark 9:38-50. Mr. Omoke submitted that the Constitution sets a high threshold for impeachment, as it was alleged that H.E. Gachagua had referred to he had with H.E. Gachagua Voko, also made references to conversations with Mr. Omoke submitted that by the Supreme Court in Odinga and 5 others, decision of 7,176,140 Supreme Court, and that the motion was an egregious overthrow of the decision of the majority which exists on the process of impeachment of the president and deputy president of an impeachment motion. Therefore, there is no framework upon which he submitted that in D and others, that is the Attorney General, this court was persuaded by on signature collection and verification and BBI process. He submitted that the same principle to the fairness of the process that the court ought to treatment of this legislation. He submitted that areas requiring legislation, in particularly public participation and the actual impeachment, president or deputy president is replaced, and expeditious hearing of petitions, arbitrary orders in favor of H.E. Gachagua, public holiday for the swearing in president, left a mind-boggling question on the F was unconstitutional, and that a declaration legislation operationalizing Article 150 of the Kennedy Kareithi Gachagua Dennis Okumu, Simon Mushans of the Constitution, and that they also instituted the petition. It had failed to establish a proper legal and procedural framework, that neither the National Assembly standing orders nor the Senate standing rendering contemplated impeachment process, proceed any impeachment process and proceedings were inadequate and unconstitutional. The petitioners are tainted by bias and lack of impartiality on the part of the motion. They advanced a historical argument concerning the events had historically been subjected to political hostility, dismissal. The petitioners then sought the following prayers: A, and under Article 50 of the Constitution. B, a declaration that public ought to be abolished, or whether accountability mechanism or otherwise, and that the lack of elaborate procedure or certainty and subsequently amount to a violation of declaration that the Article 118 sub-Article 2 that clearly orders neither the National Assembly nor the Senate had enacted an Act of Parliament providing for be undertaken, nor has the National Assembly provided for the procedure governing National Assembly Standing Order 64 and 65, or a declaration certainty and clarity contemplated under Article 118 should be coincidental to the impeachment of the Deputy President. F, adopted to an administrative expedited hearing have violated the same by commencing an impeachment process. It's the enjoyment of Article 50 and that the upset party's right to a fair trial during his impeachment under the Constitution, and that the 7 days will amount to a violation of 64(2)(b) of the National Assembly Standing Orders, and the Senate stand for Parliament that will result into a fair election, that for purposes of authenticating and verifying participants, public participation ought to be undertaken by an impartial state of a Deputy President, submitting that the process was fundamental, which requires that Articles 1, Mr. Ndegwa submitted that the proceedings violated null and Mr. Ndegwa submitted that the proceedings violated null and void. Impeachment proceedings and void. Impeachment proceedings and identify the following statutory mechanisms. Whether the constitutional framework governing the 45, whether requirement to apply Articles 144 and 1 requirement to apply Articles 144 and 140, whether the failure to apply the modification rule undermined of tenure. Whether the impeachment process violated the Deputy President, whether Parliament the Deputy President, whether Parliament in conducting the impeachment proceedings or were contaminated by irrelevant extraneous and his defense. Whether the Senate misapplied, whether the impeachment proceedings violate 18, whether the Senate acted in violate 18, whether the Senate acted in violation of its own standing order, and whether whether the continuation of proceedings in light of the Deputy President, the state obligations 19, 20, and 21. Reliefs are available where a constitutional Learned Counsel submitted that impeachment is not intended to. They argued that the constitutional ability, criminal prosecution, impeachment. It was emphasized from civil and criminal. Unlike the president, according to Mr. Legal processes. Parliament, however, they further submitted that no evidence, investigation, or civil proceedings to Article 152, which provides that Council argued that this phrase is not ornamental, but in their view, the requirement imposes transplanted without reflection. That nowhere in the Senate Hansard is the Speaker recorded as the Senate proceeded as though Article 145 applied issue, which renders the entire process unconstitutional. Failure to modify denied the alternative accountability mechanisms, flex impeachment. It was their submission that the office of deputy holder and the electorate that full term subject only to lawful and sovereign mandate, and that this is not disputed and is recorded on the right to be heard, that a hearing conducted in the absence of the principal defense participant to adjourn without violating any constitutional time. The petitioner submitted that under vulnerability and that proceeding within participant. They stated that Article 48 on the access. They also submitted that the test for bias is objective. They urged the court to address the impeachment process as absence of impartiality and presence of constitutional and procedural framework and breach of Standing Order 75. Constitutional authority is invited to interfere with parliamentary. The court differs, but where reliable and bypassed. Court differs, but where reliable and bypassed. That the Senate failed to apply the mandatory modifications, and that the Senate failed to apply the mandatory modifications, and that the cumulative defects render the impeachment null, void.
The first petitioner.
Defects render the impeachment null, void.
The first petitioner in the constitutional process and contended that the respondents had violated the national values and principles under Article 10, including the rule of law, transparency, His Excellency Gachagua had not been accorded adequate notice of allegations, nor an opportunity to adduce and challenge evidence in violation 47 and 50 of the Constitution. As such, she sought for the following orders. A, and is entitled to be informed substantially and supported with evidence the ground commencement of the impeachment proceedings by the National Assembly and Senate. B, conservatory orders do issue against the respondents, restraining them. Motion to impeach His Excellency Rigathi Gachagua, lodging any motion the deputy an order of compensation enshrined and provided for under Article 23A of the Constitution of Kenya made up of cost of the petition and any other relief. The fifth lighting of submissions. In respect fourth petitioner's case, Emmanuel Elijah Otieno in the consolidated petitions. He is an advocate of the impeachment and removal from office. President. He stated that instituted proceedings in the public interest pursuant to Articles undertaken by the National Assembly and the Senate was procedurally unfair, politically motivated, and is intended to promote accountability and good disputes or managing political differences among leaders. He challenged the legality of things before the National Assembly and the Senate and the substantive Gachagua from office. He contended that the National Assembly failed to conduct meaningful and constitutional compliant public participation as required, and stated that the public participation was hurried, inadequate, qualitatively, and incapable of reflecting the sovereign will of the electorate, given that Excellence Gachagua, having been elected together with His Excellence President, asserted that the public participation template prepared by the National Assembly was biased because it contained the allegations against His Excellence Gachagua to include his responses, thereby portraying him to the public as guilt before he had. Speaker and members of National Assembly demonstrated from the outset failed to accord His Excellence Gachagua affair proper public participation, and before considering his he maintained that no impeachable offense meeting gross misconduct or commission of crimes under national or international law had been substantiated either before the Senate proceedings, containing that the Senate violated His Excellence Gachagua's despite his illness and hospitalization, and by failing to adjourn the alleged violations of Articles 25C, 40, that the public participation and conducted by the first respondent did not of the Constitution quantitatively, and that the first respondent violated the 7th Respondent Actions Act. C, a declaration be and is hereby issued that the first respondent violated the hereby issued that the resolution of the first respondent to impeach the 7th respondent was. Likewise, the 54th petitioner neither filed any nor attended the physical highlighting of yes. Stephen Mbogwa Wanjiru and Gladys Nyambura, together with the supporting affidavits, Wanjohi. They stated that they were public interest litigants, defenders of constitutionalism. They challenged the legality, constitutionality, and procedural propriety of Gachagua as Deputy President of the Republic of Kenya, as well as the subsequent nomination of Deputy President nominee. The petitioners contended that the impeachment process before conduct, that the Speaker and the Deputy Speaker of the National Assembly had publicly over the proceedings, thereby violating the constitutional principles of impartiality. Petitioners further challenged the adequacy and constitutionality of the public participation. It's too short to permit meaningful participation, that the accusations against His Excellency Gachagua without his Parliament failed to avail documentary and electronic evidence to the public. He further challenged the Senate proceedings concerning his illness and hospitalization, and that by failing to adjourn the proceedings. Sorry, I had repeated that. Chaotic, disorderly, and marred by violence and characterized by law called for meaningful participation under Articles 10 and 118 of the C, 47 and 50 of the Constitution by refusing to adjourn the impeachment hearing despite Governor James Orengo, Senior Counsel, and Honorable Otieno Molo, Senior Counsel, maintained that the impeachment proceedings before both houses of process. The petitioners also challenged the subsequent nomination and options that affected the impeachment process and laid in the special motion that a declaration and incapable of meeting the constitutional standards required for such process. The impeachment process The Deputy President, initiated by the National Assembly and subsequently conducted by the Senate, was irregularities, bias, conflict of interest, and a violation of the right to a fair hearing. Office having been unconditionally and constitutionally under injunction restraining the President, the National Assembly, and any other state organs. G, an order revoking the nomination and Assembly as it stems from an unconstitutional process and is procedural. Articles 10 and 118 of the Constitution, processes or similar proceedings of national importance, principles of impartiality and fair hearing, and constitute cost of this petition and any other orders or reliefs. There was Edwin Gekonge, and 24 before the High Court of Kenya at Mombasa, together with their supporting affidavits, own interest and in the interest of citizens of the Republic of Kenya, Deputy President, as well as the subsequent nomination and approval of His Excellency Kindiki. That the impeachment proceedings before the National Assembly and Senate violated Articles 2, 47, 48, 50, 145, and 150 of the Constitution. He stated that the public participation process and inclusive public participation, the petition notice period for the public participation exercise of the exercise to 5th of October. The notice was issued on the very day of participation. He further alleged that the exercise was marred by confusion, violence, Constitution. He also challenged the legality of the Senate proceedings on the ground that His Excellency Gachagua was denied a fair hearing. Continue participating in the proceedings. The Senate declined to admit his absence. Mr. Gekonge prescribe rigid timelines that could override the constitutional right to a fair. The necessary constitutional modifications contemplated under Article 50 in impeachment proceedings relating to a deputy president. He further maintained did not attain the constitutional threshold required to establish Constitution, gross misconduct, and to believe that His Excellency Gachagua'S was committed national law. Mr. Gekonge also challenged the legality of Excellency Kindiki as Deputy President, stating that the constitutional time under Article 149 contemplated meaningful public participation of a Deputy President nominee. He continued. Excellency Kindiki remained a state officer serving as Cabinet Secretary at the time of nomination and had not formally resigned, thereby and sections 23 and 24 of the elections not properly constituted and therefore incapable of lawfully conforming. Mr. Gekonge sought the following orders. A declaration that the modalities put in place by the first respondent of the public participation forums that were scheduled for the 4th and 5th of special motion failed below the threshold of a proper, effective, and meaningful public. Article 10 of the Constitution. B, a declaration that the public was unconstitutional for failure to and in violation of the freedom of religion under Article 30. Under Article 32. C, a declaration process against the first interested party undertaken by the first and the second respondents was unconstitutional. Requirements set under Articles 145 and 150 of the party undertaken by the first and the third respondent was unconstitutional as it violated Article 50 of the fair hearing. E, a declaration that the impeachment proceedings of the first interested evidential threshold of the impeachment of a deputy president under of Abraham Kithure Kindiki by the President of Kenya is unconstitutional, null and void, and in contravention of Article 137(1) of the Constitution. G, Kithure Kindiki by the National Assembly is unconstitutional for failure to comply under Article 149 of the Constitution must constituency. As Abraham Kithure Kindiki had not resigned officer. J, a declaration that the independent, that IEBC Kindiki was not properly constituted to approve or confirm the qualification Kindiki under Article 137(1) of the Constitution. K, a declaration that IBC Kindiki was qualified to stand as a member of Parliament as per Article 137(1). Made him just. Mr. Gikonge, that is John Njomo, Clarence. Their petitions were withdrawn from the November 2024 as well as on the 7th it appeared as the 7th interested party by Dr. Wambua Kituku, who is executive director, as well as written submissions of issues for court determination, being whether the National Assembly, secondly, whether impeachment proceedings were quasi-judicial to fairness standards, thirdly, could review the procedural regularity of impeachment proceedings, whether the refusal to adjourn and the decision to proceed with in absentia violated the first Articles 10, 27, 28, 47, and 50 of the Constitution. Involvement in legislation and all other business of the Assembly and its committees. The President from office was one of the most significant constitutional functions and directly affected the sovereign will of the people. In such a constitutional process had to be both quantitative, number of citizens had to an opportunity to participate, and qualitative to mean that the participation had to be meaningful and capable of influencing the decision process. Given by the Speaker of National Assembly and the national citizens who relied on rural communities, citizens without access to national media, citizens reduced 290 for public engagement forums, including venues, SK Shu and Tomboya Labour College, thereby drastically limiting, take adequate steps to ensure that intended impeachment process, in particular, had failed to examples, public barazas, community meetings, vernacular radio stations, and county senate lacked adequate structures for public engagement, including mechanisms for receiving memoranda from citizens. Members of public were largely reduced to observe proceedings rather than participants in the process. They deposed that impeachment proceedings conducted by the Senate, by the Speaker of the Senate, and the Senate on the 16th was denied an opportunity to appear and be present when being tried and to challenge the evidence. That during the Speaker of the Senate and the Senate, that is Excellency Gachagua, was present but subsequently fell ill. He was then rushed to hospital for urgent medical attendance. On this ground, the Senate declined the request and consequently decided to remove His Excellency Gachagua from office by impeachment for the Constitution. Kituo stated in the proceedings of the removal from office of the Deputy President before the Senate involved the reception of evidence evaluation for ought to have been procedurally fair and to have accorded him an opportunity to be present during the trial, to be cross-examined the nature of the proceedings, reached its determination. Kituo cha Sheria contended that the request when His Excellency suffered severe and involuntary pain and unreasonable. They was bound to follow the Constitution and to observe Gachagua'S rights, that upholding the dangerous precedent by normalizing procedural shortcuts in constitutional processes, the absence of cross-examination in the in his view, a novel and serious procedural omission that including good governance, integrity, transparency, accountability, fairness, human dignity. They expressed their belief that the court had adopt a purposive and progressive approach that advanced good governance, constitutionalism, accountability, and of standards applicable to future impeachments of holders of the offices of the nation and fair hearing protections. Kituo and our Article 118 was meaningful participation and not tokenism, and that it had a meaningful opportunity considering the nature and the impact. It was submitted that the removal of a deputy president from office was not an ordinary process of democratic implications. That Article 18 had to be read together with Articles 1 and 10 of the Constitution, and that power in a delegated capacity when Parliament embarked on a process to ensure that the people themselves were accorded a meaningful admitted that in such a context processes. The organization submitted that public participation in particularly important where the process concerned the removal of a on the Mwangaza versus Speaker of National Assembly case, N2A and 190 sabbatical Constitution mandating inclusive and meaningful citizen engagement. Impeachment. It was further submitted that the Constitution did not intend a scenario an otherwise popular deputy president could be removed due to political rivalry. The abuse interested party submitted that the one-day Gazette notice under public participation as such short time could not reasonably reach the citizens who relied on accessible and localized information channels. On the participatory mechanisms ordinarily available to them, including boards and accessible announcement and representation of the people and decentralized partisan platform, and restrictive mode whereby all 290 constituencies will have venues, single venues, diluted constitutional high-level distributions were particularly impossible. The structure undermined meaningful engagement, disabilities, workers, and citizens living far from county headquarters. Gravity required decentralized, not highly structured and restrictive model of organization of the processes. Attendees were given limited time to that format did not allow robust rationality or factual basis of the impeachment. Interactive and not merely our formalistic exercise. On their citizens could tick boxes indicating support or unpermitted, no opportunity participation to checkbook voting rather than constitutional engagement. They acknowledged in their submissions that the standard requires assembly to have actively mobilize public awareness through the failure to of the notice and consequently diminished participation. The process manner and procedurally shallow through forcing the validity of the impeachment of His Excellency Gachagua. It was further matter of national constitutional significance affecting the democratic will of the electorate and the sovereignty of the people, and that accordingly the electorate and their democratic choice. Constitutional mandate, when it undertook a process the nation's adverse to rights, reputations, and the tenure of office, it was the hallmarks of a quasi-judicial trial form in the form of removal from office, and that Articles 47 and 50 of the Constitution and the Fair Administrative Action trial burdened with reputational examined and to be re-examined, all the more imperative. That's scored that fair trial rights were under regular Stephen Odede versus Court Martial to be unduly impeded, and that a trial board circumspect in purporting to limit and take away such crucial right. There was never to be any derogation sui generis, the logic of a greater force. His Excellency Gachagua'S fell ill, was admitted to be cross-examined. It was submitted that a fair process entailed by way of cost or by way of time, that the right to a fair trial indicated that the right to fame, a fair opportunity to answer, and the opportunity to be present. It was further submitted that if the Senate could adjourn an entire then refusing to adjourn to accommodate a hospitalized party where fairness and constitutionally infirm. They argued that and included the right to attend, the right to correct and contradict the allegations made against one. Further, attendance or effective participation and unable adjournment amounted to a denial. Conduct had made it impossible to continue the hearing, or if after due emergency and counsel had sought an adjournment, adverse material in those circumstances, it was further submitted that in impeachment, where adverse oral evidence was received and credibility, the denial of which followed Articles 10, 47, and 50, where a short adjournment would have Kituo cha Sheria submitted that court's constitutional requirements. Kituo cha Sheria submitted that court's constitutional requirements were breached, relying invaluable safeguards were breached, relying invaluable safeguard against impunity and an abuse of office in the exercise of public power, even in the exercise of public power, even in Kituo cha Sheria recalled the Court of Appeals statement that the process of removal followed as laid down in the Constitution and the statute. Accordingly, they sound all state organs or enacted, applied, or interpreted any law or made mention and re-examination, especially in a medical emergency, subverted human king, the court to supervise the National Assembly and the Senate debate or to send ultra-vires. A declaration that the Senate, acting as a quasi-judicial body, violated a reasonable adjournment an order of remit in strict conformity with constitutional and statutory fair determination and such other orders as the court made in fair impeachment process. Kituo cha Sheria procedural safeguards precisely because His Excellency Gachagua'S hospitalization proceeded in absentia and delivered to rewrite politics, but to enforce procedure and dignity. We'll now proceed to recess. The National Assembly and the clerk to the National Institutions. The National Assembly and the clerk to the National Institutions. They jointly responded 1st of October 2024 on the grounds of opposition and procedural fair, and that all actions taken complied with Articles 145, followed Article 150, sub-article Articles 144 and 145 of the and that Standing Order 65-2 of the National Assembly, explicitly state one-third of all members. That public participation was adequate inclusive and compliant with Court Order 2024. Public hearings were held on the 4th of October 2020. And the public will submit views by way of email, post, hand delivery. We are also able to visit. The public participation report was published. They asserted that the of the Deputy President defense, as it was meant to gather the Deputy President's 8th of October 2024, where he appeared in person with his Kirinyaga County Women Representative Office during public participation exercise. Woman representative herself, since she was vehemently opposed that obstructed the public participation out of the impeachment, and 44 voted against. And Article 145.2 of the Constitution. That on the 9th, Article 145.2 of the Constitution. That on the 9th of October, constitutional or otherwise wrongdoing, and prayed that in respect to their submissions, constitutional petition was led by learned counsel Mr. The following issues for this court's determination. The constituted petitions relating to the impeachment of His Excellency Gachagua. B, whether the subject and 103 of the National Assembly and the Senate standing orders. Proceedings are pending. C, whether proceedings are pending. C, whether D, whether the petitioners have demonstrated conducted before the Senate. E, conducted before the Senate, the sovereign will of the electorate expressed contrary to Articles 1, 2, and 38 of the Constitution, valid, and whether the petitioners are entitled to politically necessary to uphold accountability and the rule of law. Their positions remain that and that the Constitution vests sovereign power in the that the Constitution mandates public participation of strict timelines requirements of the 2/3 in both houses, making analysis with the United States, Philippines, Brazil, South Korea, is a constitutional safeguard against abuse of 5 of impeachment proceedings admitted that such power is only residual and supervisory, not appellate. Court's role is limited to ensuring procedural compliance and citing the cases in Wambora and Sonko. They asserted that the court Philippines in Sarah Duterte, which is on political questions. That Standing Order 89 of the National Assembly bar discussion on matters pending in court, and the matter is sittings. They stated that the petitioners did not raise any sub judice objection. The National Assembly and clerks submitted that the Constitution itself imposes tight time. Prolonged proceedings will cause political uncertainty of parliamentaries' power, and Article 120 in Mbarak Issa Kombo's case. It was their father before public hearings were held at county and constituency levels. 3,083 citizens submitted views, which the public views template was provided in English and Kiswahili, is reasonableness, not perfection, and Treasury and Planning and 4 others versus Okoita and 50 assessing public participation adequacy. The response was not required to the circulated, was required to be allegations of violence, intimidation, and that isolated an entire process. They also in Parliament and recorded in the Hansard, which is a valid parliament, was properly particularized and set out 11 detailed grounds in the Wambora's case of being serious, substantial, and precise constitutional provisions. That the motion was supported by of 233 MPs, and that the Deputy President prior notice of the charges, he filed his written response and appeared in person. With also submitted that His Excellency Gachagua'S defense was for the vote, and that the 2/3 gender principle does not invalidate Parliament. Been fully complied with. On the 1B, it was submitted that this was not a condition precedent to Parliament's validity. That Article 261 provides a mechanism for action by the President has occurred to resolve. They contended that accepting the petitioner's argument would void all legislation and actionable outcome. On the allegation allegations were unproven, and further that the Deputy Speaker only did not vote. Further, no recusal motion was raised during the proceedings. They stated that and that the threshold had not been met in this matter. Article 3A mandates the Senate convene and hear such charges are not mandatory, and the semicolon that the discretionary power into a mandatory committee on the 9th of October failed as it was not seconded, and the Senate then or by a committee, and that is silent. The Senate may regulate exercise of procedural autonomy to ensure expedition. Council submitted that a fair hearing in the Senate as was represented by Council National Assembly witnesses, and he filed witness affidavit that the Senate did not refuse an adjournment unreasonably, as seen no medical evidence of either doctor for within the constitutional time frame. But this motion failed on. The clerk submitted further that the decision to proceed in absentia did not violate fair after cross-examining the